So, why do patent attorneys take so long drafting a non-provisional patent application? For any of you out there that are tinkering with AI, you can easily go to Gemini or Chat or Claude and put in details about your invention. And in all frankness, Gemini, Chat, Claude, they will draft a decent patent application for you. So, why does the attorney take so long? And are there any advantages to using an attorney over AI to draft your patent application, your non-provisional patent application? Um, there are some definite benefits to using an attorney over AI. Attorneys think, AI doesn't think. So you can put a lot of details about your invention into AI. They will draft something that looks remarkably similar to a patent application. You can go ahead and file it. You'll get a filing date. The patent examiner will look at it, they'll review it. But what you don't have is you don't have attorney judgment and you don't have any thinking. So if there's something in your detailed in your description to the AI that doesn't really make sense, an attorney is going to push back on you and say, "Hey, wait, this doesn't make sense. These two pieces can't be next to each other." Or if it's a software program, this doesn't follow. Where is the connection here? And AI won't notice that. It'll just either make something up or gloss over it. I've seen it before because I've had clients file a provisional using AI and then they bring it to me for the non-provisional. And I say, this doesn't make any sense. Did you give the right information to AI? And they say, I must not have. So that's where the attorney comes in. You can certainly use AI. You can try to scratch something out. Maybe it'll end up helping the patent attorney when they're drafting it. But the other big concern with using AI is when it comes to the claims. So you can have a decent description of the invention, but the claims are really the heart and soul of the patent application. This is what will end up being your intellectual property, the claims that governs what you own. And if the claims were written by AI, they might be okay, but they might not be okay. So they might not be broad enough, or they might bring in elements of the invention that aren't really required or don't really make any sense. And if you're somebody that is not a patent attorney and you haven't filed a lot of patent applications, you'll read the claims and say, oh, hey, those look good. But you don't have the critical analysis that an attorney has. And so for that reason, the AI drafted claims might not be as strong as you would like them to be. So you can certainly tinker with AI. It's a lot of fun to do that and see what it comes up with. And in a lot of cases, I'm even surprised. I say, wow, that comes up with something better than I would have expected. But it does have gaps. It does sometimes make stuff up and has hallucinations. It does bring quote unquote slop into the application, information that is just flat out not required and just sort of a waste of the part of the application. So there are definite benefits to using a patent attorney over AI. Maybe that changes someday. Maybe it doesn't. We'll find out. But for now, the critical analysis, the thinking, and the judgment are what the patent attorney brings to the table. And as you can imagine, that is actually somewhat time consuming. And so it takes weeks to months to draft a non-provisional rather than 30 seconds, which is what Gemini can crank something out at. And one day I'd like to be maybe a little faster, but not 30 seconds fast. So we'll see.